Winifred Fowler-Sullivan. I'm the chair of the Department of Religious Studies at IU and affiliate professor in the law school. The lecture today is sponsored jointly by the Department of Religious Studies and the law school. And I'm really thrilled and delighted to introduce my friend and colleague, Benjamin L. Berger, professor of law at Osgoode Hall Law School at York University in Toronto. Professor Berger holds an LLM and SJD from Yale University, as well as degrees in religious studies and law from the universities of Alberta and Victoria. Upon completion of his legal studies, he served as clerk to the Right Honorable Beverly McLachlan, Chief Justice of Canada. Ben is editor-in-chief of the Canadian Journal of Law and Society and a member of the British Columbia and Ontario bars. He is also the principal investigator or co-investigator on several major grants from the Social Science and Humanities Research Council of Canada. An expert in criminal and evidence law, as well as in the study of the intersections of law and religion, Professor Berger is an astute analyst of contemporary legal theory and comparative constitutional law. Critical comparative study of the actual contemporary working of liberal guarantees of religious freedom and the varieties of religious establishment/disestablishment in the world today is a relatively young, if increasingly crowded field. Scholars who have the interdisciplinary training to understand the details of the intertwined legal and religious histories that combine to produce modern legal secularism are rare. Professor Berger's subtle and sophisticated analysis of the distinctive ways of the Canadian case is exemplary. As you will learn today, Ben's quiet but incisively intelligent and insistent voice has the capacity to reorient your perception about important matters in powerful ways. In encounters at academic meetings over the years, as well as during a visit to Osgoode a couple of years ago, Ben has taught me to see objects I thought I knew in startlingly new ways. I don't do jokes very well. They seem to be demanded in the cross-border sibling relationship that is Canada and the US. Jokes about hockey or guns, in my experience. For my own part, Ben's retelling of the North American story in a new register in the context of now global attention to how law matters is a significant corrective to the blindnesses of US exceptionalism. Thank you for coming. You are really in for a treat. So the title of Ben's talk is Secularism, Sovereignty, and Symbols. You can read The Case of Quebec and its Charter of Values.
Well, thank you so much, Winnie. It's a great pleasure to be here. Both a wonderful experience in religious studies, where Winnie has welcomed me along with the organizational work of her office, and I want to recognize Abby for all the work that she's done to arrange this. And a real pleasure to be here in the law school, which in many respects I'm just getting to know, but is a law school in certain regards very much after my own heart, with the Center for Constitutional Democracy. I added a series on constitutional systems of the world, and there's so much work being done that is of interest here. The Center for Law Society and Culture, Winnie mentioned the new editorship that I'm taking on with much trepidation of the Canadian Journal of Law and Society, and so many interlinks there. And I hope that those of you working in those areas will be in touch if there's ways in which we can collaborate. My greatest thanks, of course, is to Winnie, who has been a wonderful friend, mentor, and scholarly interlocutor in these areas. And so it's a great delight to be in Indiana. I want to begin actually just talking about an article that draws out a couple of the themes and patterns that I want to cull from this particular case. In 2008, James Whitman, a professor at Yale Law School, published a very interesting article in a journal, Historical Reflections. And the article is entitled Separating Church and State, the Atlantic Divide. I'm fond of this article for a couple of reasons that relate to themes that I want to draw out, and so I'll say something about that. There's also a little point of irritation in the piece, and it's actually unrelated to the argument. I want to come back to that because I want to exploit the irritation just a touch as well. But first about the argument, which I think is actually just quite neat. Whitman asked a really nice question that was essentially about the intelligibility of the terms that we use to organize the various happenings that occur in the world of law and religion. And particularly about how those organizing concepts can distract us from other points for reflection, maybe even more fruitful points for reflection. This piece shows how these broader organizing concepts can obscure the world of the particular and our understanding of that world. And the concept, if we can call it that, or the theme that was of interest to Whitman was the so-called notion of the separation of church and state, right? Some version of non-establishment. And his question was a nice one. It was a nicely packaged, interesting question. His paper asked how it could be that both Europeans and Americans claim that they enjoy in their systems a true separation of church and state, claim that the other manifestly does not, and both be right. So you see, he noted that Americans look to the substantial schemes of state funding and support that exist in Northern and Western Europe for religion. And there I'm talking about for schools, for churches, even for clergy. And they say that this obviously and strikingly fails on a test of separation. By contrast, Whitman notes that Europeans look to the United States and the saturation of legal discourse and political life with religious content, with religious language. They note the salience of religion to public policy, and they say that this is an egregious breach of a defensible notion of the separation of church and state. And Whitman's first contribution, interesting, modest, but very helpful, is to point out that there's at least two different kinds of relevant separationism that we can identify if we focus our attention on local particularities. Both of these approaches to separationism have their virtues and have their pathologies, and therefore will demand a kind of normative assessment. But we actually miss these differences when we focus on just broader claims about separation of church and state. And so you see, he says that one can be concerned, quite rightly, with institutional separationism, where the worry is about the distance between institutions of state and institutions of religion. And this is an American sort of construction, he says. Or we can be worried about the separation of religion from politics and law, which he says is the most pressing concern in the European setting. And so his claim is that both continental Europe and the US have intelligible claims to separation, and yet both are shocking to the other, right, on this ground. So Whitman goes on to make some important historical claims about the ways that these two approaches shaped up. And the most interesting is a very persuasive argument that a common account for how these shaped up differently is plainly inadequate. And that common account of how we get these two versions of separationism is that there's something distinctively Protestant in the American form of this, and something Catholic about the European approach. And Whitman does a great job of showing that this is just patently unsatisfying as an explanation, sociologically, historically, politically. And instead he roots that difference in historical sociology. Right? He says that in Europe, over many centuries, the state gradually absorbed many of the historic functions performed by the church. And that process never happened in the United States, which left a really salient and important layer for religion and religious debate, religious language in the formation, discharge, and delivery of public policy and public services. So this is seemingly quite tangential at this point, and I'm prevailing on your patience. Why would you begin this talk about Quebec with an account of Whitman's paper. I think it's interesting in itself, but it's really here to point to a few things that I want to do in my talk that you've sacrificed your lunch to. So a few things. First, you'll recall that I said that there was a point of irritation in this piece, and I would touch upon it, something quite separate from the argument that I identified. And in fact, Winnie has gestured to this already. And that point of irritation is the title. It's the idea that the Atlantic Divide is a plausible way of talking about a comparative approach to the study of state, law, and religion, when the focus is really the United States and North and West Europe. On the European side, to do this and to call it a claim about the Atlantic Divide is to do a lot of violence to Britain, right? To do some fancy footwork around the varieties of separationisms that happen on the continent. But more pertinent to the talk today, what Whitman keeps calling the North American is insistently about the United States. And the case that I want to explore today, the Quebec case, is really about pointing to the much richer range of North American happenings around the relationship between law and religion that thicken up the resources we have to talk about an experience of religion and state in this continent that I think makes it much more interesting. So the example I'm going to give you today, as you know, is from Quebec. And let me just pause here to note what is often forgotten on all three sides of the North American border, that there's an actually conjoined history of interwoven constitutionalism in the histories of Mexico, Canada, and the United States. Right? In certain measure, this is about the stories of Spain and France and Britain, all overlapping. The people that see this most clearly, that it's a conjoined history of constitutionalism, is of course the indigenous peoples, right? For whom the experience of European constitutionalism in North America is not about the United States, Canada, and Mexico. It's something more broadly patterned than that. And turning to the case at hand, it's too often forgotten in both Canada and the US that the story of Quebec is actually a story about the American Revolution and the US Constitution. English Canada being, up until the American Revolution, almost non-existent, and after the American Revolution, English Canada being basically comprised of American loyalists. The Revolution and the Manifest Destiny project, to the extent that it existed, created the alliances that enabled Canada and Quebec to plausibly exist as countries. And so one thing I want to do is less argumentative and in a way more as a reporter today. I want to offer something that thickens up our resources for thinking about religion and state in North America. But second, the story that I'm going to offer from Quebec is in service of another point that is sympathetic to Whitman's piece. One of the lessons of that article is something that I think is very true, that in order to travel large conceptual, historical, and sociological distances, concepts in a sense have to become thin and light. To travel those distances, they have to thin themselves, become light in some fashion. In doing so, they travel better, but they also make themselves more amenable to exhausting rapidly in their descriptive utility when we're trying to understand what's happening in each of these places. So, by way of example, once Whitman is done with the concept, if separationism is going to embrace anything more than the local, it's going to be very thin indeed, a very vague gesture. My point for the talk today is about appeal to the concept of the secular and what secularism, people say, demands. And the lesson of the example that I'm going to give is a kind of skepticism about claims about the nature of the secular. This is a helpful literature already, showing that we might be best off speaking in terms of varieties of the secular or particular formations of the secular. And this is a really useful literature, switching from secularism broadly to the varieties and particularities. Personally, I'm not yet willing to give up on some reflection on the project-like elements or the resemblances between ways that secularism moves and appears in the modern world. Here, secularism understood as just a sort of repertoire of moves that are used in untethering religion and political authority. So I'm interested in both the varieties and the little things that persist, thin but interesting, at the broader level. But again, at that level of generality, if we just think of it as some moves that are available, the concept doesn't seem to have much explanatory power that doesn't end up drawing for its purchase on the local histories, on the local particularities. And so the second purpose in the case I'll explore today is to urge some greater skepticism about and modesty in making invocations of the demands and nature of the secular. It may just be that such claims hide more than they reveal about what's happening constitutionally. So before I get to the case itself, let me just point to one more theme that I want to draw out, one that binds these first 2 points. When we're invited to think about the relationship between religion and political sovereignty, our minds probably most easily and quickly travel to exotic places. Right? So we might think about Egypt quite properly right now. We might think about India, Pakistan. Or if we're thinking about North Africa, France might come into the picture in some fashion. But the story that I'm going to tell now will show, I hope, a very local, powerful, concrete, politically active way in which these claims about the nature of the secular, apart from whatever conceptual coherence or descriptive utility they have, about how these claims about the secular are very closely tied up with projects of sovereignty. So, finally, to the case. I owe you this case. In the fall of 2013, a minority government formed by the Parti Québécois in Quebec, the Sovereigntist Party in Quebec, made news in Canada and in many places around the world by proposing to institute what it called a Charter of Quebec Values, called by others a Charter of Secularism. And that label, Charter of Secularism, came as a product of Premier Pauline Marois' claim that the legislation was designed to codify and entrench principles of state neutrality in matters of religion, and specifically to codify Quebec's distinctive commitment to its secular nature. To give you some sense of the purpose and the thrust of the legislation, this is Section 1 of the bill. In the pursuit of its mission, a public body must remain neutral in religious matters and reflect the secular nature of the state, while making allowance, if applicable, for the emblematic and toponymic elements of Quebec's cultural heritage that testify to its history. Now, let me just do a little sidestep to talk about these emblematic and toponymic components. If you haven't been to Montreal, to Quebec, this is one element that was very contested in the emblematic components of Quebec cultural heritage. This is Quebec's National Assembly. Note, National Assembly, right? Where just above the speaker's chair, you see, and in the cutout, really helpful image, a crucifix hanging, put up in the 1960s. This is really about, this is a term that I just have a lot of affection for right now, laïcité, catholicité, right? This is sort of like a kind of laïcité, and I'll come back to that concept shortly, that is about a certain cultural heritage, and I'm gonna come back to that. If you're in, this is from old Montreal, but right in the center of the city, Montreal, right, Mont-Royal, and there's this mountain. It's only a mountain if you're not from Alberta, where there's real Rockies, you know. It's a hill in the middle of the city, on which there is a large cross that was put up in 1643. The first one was put up in 1643, and you can kind of see it poking above, from wherever you are in the city, you can see this cross up there. It's easiest at night, right? It's illuminated. So where you are in the city, if you're not surrounded by tall buildings, and if you're on the right side of the mountain, you see this. And then toponymic, I had no idea until the bill came out what this meant. It's place names. And this is just, everything there is Boulevard Saint-Laurent, right? Saint-Denis, right? Saint-Hubert, right? And all of the places that are named in terms of clearly Catholic reference. So to give you some context, this proposal rose up on a set of concerns about the accommodation of religious practices in the province of Quebec over the last 10 years or so. And you appreciate, of course, that issues of culture, of national identity, are particularly potent in the province of Quebec. And so these concerns about religious accommodation, which were found all over Canada, actually had a particular purchase in Quebec. And certain court decisions about the demands of the Canadian Charter of Rights and Freedoms, the demands of legal multiculturalism as a state policy in Canada, these produced worries in Quebec, worries that eventually led to the establishment of a commission of inquiry in Quebec into practices of accommodation. This is something you might be familiar with by its name as the Bouchard-Taylor Commission. The Taylor in Bouchard-Taylor being the Canadian political theorist, Charles Taylor. And so they did this work of an inquiry into practices of accommodation and attending to this sense of concern in Quebec around issues of religion and culture. And the report made recommendations regarding the approach to the accommodation of religious difference. But fatefully, in my view, and I think this was a mistake, the report also involved substantial attention and reflection on defining the nature of the secular. Right? So it ended up, unsurprisingly from the author of A Secular Age, with all of this language about open secularism, right? Closed secularism, the nature of Quebec secularism. One of the things that the report urged was that a government should issue a white paper, a proposed bill, right, on these issues of religious accommodation. Well, unforeseen by the Bouchard-Taylor Commission, the party that takes this up is a minority Parti Québécois government. And it took up this suggestion, and it offered this bill that you've seen the first component of, and it did a number of things, this proposed bill. It made amendments to the existing human rights instruments that would emphasize the priority on equal rights, would give a broad kind of frame for managing accommodation requests. But an important amendment was the addition of the following new whereas, right, preambular statement to Quebec's Charter of Human Rights and Freedoms. This is its rights protecting document, its human rights instrument within the province. The bill said, whereas equality, can you see that not too badly? Is that fine? Yeah. Whereas equality between women and men and the primacy of the French language, as well as the separation of religions and state, and the religious neutrality and secular nature of the state are fundamental values to the Quebec nation. It's new whereas, new component. So this new bill was very much framed as an appeal to something called the secular nature of the state. It was a statement of belief in secularism and a function of what were framed as just the demands of a secular state. Indeed, the claim was even a little more particular than that, with the official French text, of course, not referring to the secular nature of the state, right, but instead to the caractère laïque de l'État, right, the laic character of the state. And indeed, one of the government's claims was that this was all part of a distinctively Quebec link with France. That there was, in a sense, and I use this consciously, a kind of indigenous French concept of secularism that they were simply giving expression to with this bill. Well, the bill did more, requiring that anyone accessing public services not have their faces covered. This is just purely a reference to Denis Coderre, right? Nothing else is of a concern there. But the real flashpoint in the proposal was the government's imposition of a restriction on the wearing of religious symbols. And if you know of this case, this is the part you likely know of.
employees of public bodies would be prohibited from wearing headgear, clothing, jewelry, or any other adornments that overtly indicate a religious affiliation. And here, public bodies, think of this, includes government departments, municipal authorities like transit authorities, school boards, colleges, universities, hospitals, health services, childcare. So after a transitional period, right, all of these people, doctors, healthcare workers, nurses, professors, right, judges, police officers, prison officials, none would be permitted to wear these kinds of clearly and what was called conspicuously religious items. And so this was really the core of the bill. Right? And Abby put up a version of this on the poster for today. You see un état neutre au service de tous, a neutral state in service of everyone. And they actually did, this is from the government of Quebec at the time, they did this infographic, right, which I'm going to pause on. I don't want to bore you with details. I think it's actually quite interesting. They issued this infographic and they said, well, here are examples of non-ostentatious, right, symbols that would be permitted. So this first one is totally befuddling, right? It's a crescent moon earring, right? Which the only thing I got from friends who were Muslim friends was like, I've never seen them, but they're neat. Where can you get them? And then a small cross, the wildly popular and common Star of David ring. And then really, the examples of ostentatious, right? The common pectoral cross, right? Which is strangely framed with a spread collar. And so this is anachronistic in and of itself. But then you see really what's of concern, right? Headscarves, to some extent turbans, to some extent kippah. Right? So you see that this is a debate about religious symbols, about the state defining the meaning, the symbolic valence of religious symbols. And it seems in this way more familiar or kind of natural to Turkey or to France, right? But it's just a drive up the road from Maine, Vermont, New York, right? I mean, this is what we're talking about. This is North American tangling with law and religion. And we also see here, of course, the point that's made about these symbols debates in France, elsewhere. You see what is sometimes framed as a paradox of secularism, right? Which might just be not a paradox, just the way secularism works, which is the state up to its elbows in defining theological issues in service of doing the work of secularism, right? It has to decide what this means and what it reflects and why it's religiously significant so that it can then prohibit it, right? It doesn't know if it can prohibit it until it defines its content. Well, this sparked enormous debate, enormous excitement, and there were substantial portions of the population in Quebec that supported the bill. There were substantial portions of the population outside of Quebec that supported the bill. But within Quebec, minorities, Anglophones, overwhelmingly concentrated in Montreal, as well as professionals, universities, institutions objected fiercely. And voices from outside of Quebec, sometimes called ROC, right, rest of Canada, right? Voices from ROC cast it as multiculturalism in Canada, right? Xenophobia in Quebec, right? It became sort of like, this is something that Quebec has always been about, right? This is the elision that happens when you have a nation that defines itself strongly in terms of cultural identity in the midst of a fairly diffuse sense of cultural identity. It slides into these claims of xenophobia. But there's much of this debate, and there was much kind of humor also in pointing out a bill that was just riddled with problems. So, for example, it said nothing about the beard, right? And so somebody did a posting of saying, well, now, sure, you've done a good job. This is all in a sarcastic register, right? You've done a good job defining some symbols, but Premier Marois, you have to go further and distinguish the Muslim beard. But of course, your problem is to distinguish the Muslim beard and the hipster beard, right? And then you have to really talk about presumptions. Like if you're close to the university, it's more likely to be hipster. Whereas if you're, and so just these kinds of inconsistencies. This is one poster that was done by a candidate for Montreal civic office who said,
really this is a neutral state in service of all. Took that from the slide.
Yeah.
Right. And then said, this is really about things that make me uncomfortable, and in Quebec, right, the Toronto Maple Leafs, right? Things I like to see, right, the Montreal Canadiens, right? And then some other things that are interesting too. Donald Trump, apparently, she made her uncomfortable. Angelina Jolie, something she liked to see. But as I said, the fissure, which is the point I want to focus on, in kind of Quebec, rest of Canada, also took on some pretty fierce forms of revisions, right? So there were these claims about xenophobia, about what laïcité looks like to those living a different form of secularism. Importantly, reaction to this proposal was also that it was clearly unconstitutional, judged against the Canadian Charter of Rights and Freedoms, which was the rights-protecting component of the 1982 Constitution. Surely freedom of religion, or even just state equality, would prohibit this kind of a proposal. And I have to say, surely it would. Right? It was patently unconstitutional. There's very little of interest to say about how clearly unconstitutional this was, but the response was, I'm not interested. This is an expression of the laic character of the state. I'll come back to this. Of course, this winter, the Parti Québécois called a snap election in the hopes that this issue would galvanize its support. They tried to control the election so that it looked like a referendum on this bill, to make this the major issue. They failed in doing so, and in fact on Monday the election was held, and they lost dramatically. Indeed, Premier Marois is no longer the premier, she lost her seat, right? Now, if you think this kills the discussion of this bill, you're wrong, right? It's out there now, right? It's floating, it will be returned to. So, what I want to do now, and in the little bit of time I have remaining, is to try to make sense of this piece of legislation by telling two different possible stories about where it sits. And this is a remarkable moment, in my view, in North American law and religion. I think it's also, it was deeply troubling as a moment from where I sat. But how do you make sense of this? And there are two different stories. And the first is a story of discontinuity and change. This story begins with recognition that the defining character of Quebec in the 18th, 17th, and 18th century origins of the country was its devout Catholicism. Quebec society was thoroughly Catholic in a sea of Protestants. And indeed, it's interesting to note, for those of you that kind of know more about the kind of Catholic Church history, the ultramontane movement within the Catholic Church, the hyper-sovereigntist version of papal supremacy, the version of Catholicism in which secular authority was clearly, avowedly in service of papal authority, actually got strong traction points in Quebec. It had a real life in Quebec, ultramontanism. Indeed, it had that life all the way up through Confederation in 1867. And yet, if you look at the polls now, and this is the story of discontinuity, Quebecers are amongst the least willing to identify as religious in Canada. They're highly skeptical of religious authority. They adopt positions on social issues that are in tension with conservative forms of Catholic life. And so there was a radical transformation of life in Quebec around its Catholicism. That radical transformation took place in the 1960s in what we refer to as the Quiet Revolution, right? An utter change in Quebec society, the heart of which, over about 10 years, was the formal untethering of the Catholic Church and political authority. The Church withdrew, was forced to withdraw, from basically all dimensions of social and political life. And this hard break, this rapid transformation, touched on education, it touched on politics, it touched on everyday life, habits of everyday life. So, read in this story about a highly religious society becoming non or even anti-religious, this secular charter is a kind of speed bump and trouble spot
in the working out of secularism. On this story, Quebec is a kind of paragon of a process of secularization. Sure, the Quebec Charter is challenging. It might not be accepted in all of its specifics. But those specifics are also intelligible, in part, read as a dimension of the hard break in the 1960s with Catholicism, a kind of social trauma. So this is a contested moment on this story. For sure, it's contested. It's contested about visions of the secular, about what secularism should look like. And on this kind of a quick reading, the legislation here is about working out a particular concept of the secular. Right? Contested, but that's what's at the heart of it. And yet the problem with this story, which is really the heart of the story told about what was going on here, is that it turns out the notion of the secular, or the focus on the secular, is actually doing a lot of mischief in our understanding of what was going on in this case. It's running interference with what's happening at this political moment. And it's something that I'm intimating might often be true, of focusing too much on the broad notion of the secular. And just to exploit one crack in the wall, this appeal the Parti Québécois made to a Quebec vision of laïcité that was common with France, it's baldly anachronistic. Right? The laïcité in France that took root, that is now recognizable as what we think is French laïcité, and even though we know it's much more complicated there as well, established really firmly in 1905 with the Third Republic and the law on the separation of churches and state at the time. Of course, Quebec society remains thoroughly Catholic through this period, right? All the way into the 1960s, absorbs other traditions. It just simply is not in contact with this French tradition of laïcité, but there is, to be sure, something attractive about appeal to France for some of the people in Quebec. But that appeal to France and its version of laïcité is not a function of historical accuracy. It's a function of something else. And so here's the second story that you can tell about this. This story looks to the origins of the Canadian state and sees that the Treaty of Paris, 1763, which settled the claims of the English, French, and Spanish crowns over North America, included only one concession to the French crown, and it's near the bottom. His Britannic Majesty, so you have basically, it's a nice section from the Treaty of Paris, because you have this long sets of things that the most Christian king will give up, France. Right, and it's ceding land, ceding more land, and more claims of territory and land. And then you get His Britannic Majesty on his side, agrees to grant the liberty of the Catholic religion to the inhabitants of Canada. That's the central offer in the Treaty of Paris. The Quebec Act, 1774, the essential element in the founding of the province is in these red brackets. And here you see a declaration that His Majesty's new Catholic subjects, right, will have, hold, and enjoy the free exercise of the religion of the Church of Rome, subject to the King's supremacy. And there's a whole story to be told about those subject tos that riddle the constitutional text. And then in the British North America Act, 1867, the Confederation document, the key protection, and what the Supreme Court of Canada, as late as the 1990s, said was the sine qua non of Confederation, was the protection of Catholic schooling. Everything else going on, no, what is the provision without which Confederation would not have happened? In the Supreme Court of Canada's reconstruction of the history, protection of Catholic religion. This story also looks to more modern constitutional and political history. It recognizes that the quiet revolution that I spoke about earlier was joined with a growing sovereignty movement, one in which the reconfiguration of the relationship with the church was associated with a reconfiguration of Quebec's place in Canada and the rise of this Parti Québécois. And this story also puts the so-called Charter of Secularism in a frame that includes the fact that when the Canadian Constitution was patriated in 1982, the act when amendments to the Canadian Constitution were put under domestic control, rather than the Canadian Constitution being a piece of imperial legislation, which it was until 1982. Right? When it domesticated the Constitution and introduced in 1982 along with it the Charter of Rights and Freedoms, right? It did so without Quebec's consent. They never agreed. And that failure to sign on to the constitutional project in 1982 led to referenda on separation from Canada. It led to the famous secession reference in the Supreme Court of Canada, which is a high court speaking about the principles that should govern the secession of a component of the country. And it led to the Parti Québécois working since that time as essentially a sovereigntist party, the dominant force moving again towards some form of sovereignty for Quebec. And so if you frame the Quebec Charter in this story, what does it look like? What does the Quebec Charter, this moment, look like? Well, let me lay it out in this way. The Parti Québécois had struggled in recent years in its sovereignty platform, and in no small measure for economic reasons, because Canada had left in 2008 in the economic downturn basically untouched, basically unscathed by that whole economic downturn. So the Parti Québécois suffered, right, politically in this period of time. Now add to that the observation I made earlier about the proposed charter, true I think, that it's manifestly unconstitutional. Judged against the Canadian Charter of Rights and Freedoms, it seems manifestly unconstitutional. And so you ask, well, why introduce the bill? The introduction of this proposal, right, excited passions about religion. It excited passions about difference, passions that one finds in many places, but very strongly within Quebec. And so the claim that this was about a Quebec way of doing things, a Quebec way of doing law and religion, Quebec's pursuit of secularism, introduced a very potent kind of Quebec ROC divide, right? Quebec, rest of Canada divide. And then think about how it would play out if indeed the Charter of Secularism was challenged in the courts. What if it were passed? What if it were challenged in the courts? Well, a bill very intentionally called the Charter of Quebec Values, right, specifically called that, would go up to the Supreme Court of Canada, and this federal institution sitting in Ottawa would be forced, no question about it legally, would be forced to declare the Charter of Quebec Values unconstitutional by reference to a constitutional instrument that Quebec never agreed to. Right? Quebec Values unconstitutional in this confederation, in this constitutional makeup. This is a sovereigntist fantasy. Right? It is set up a fantasy about sovereignty. So at a time when there was a lack of appetite on questions of sovereignty, the invocation of secularism served particular purposes in exciting a political debate. It promised a boost in the polls, which led to that snap election. And if the bill passed and were challenged, it couldn't be better. Right? It would fail, and it would fail in a wonderful way for this Canada-Quebec divide. So this story makes the Quebec Charter a story of continuity, not of radical change. This is a story about religion in Quebec always being the basis for distinction and differentiation, for claims about a unique relationship with religion since the Treaty of Paris, right, to constitute its political community, up to this particular secular charter. It's about the management of religious identity and religious difference being part of how you manage political identity and projects of sovereignty. This is not about the concept of the secular or its demands in any universalistic or ideal sense. Of course it's about secularism. It's also about secularism, but only really as a currently available and potent marker for a kind of debate about the distinctiveness of a relationship to religion and therefore
of the political community. So let me then close off this piece of North American constitutional history with a return to the point that I was querying early on about the utility of organizing the study of law and religion around a study of the nature of the secular, the demands of secularism. You'll recall that I said that there are some things that can be gained by that kind of reflection. I'm not saying I don't. In fact, I'm kind of have an affection for that kind of reflection. There are things that can be gained from that. We can get a sense of how concepts travel. We can perhaps take on lessons from those kinds of struggles. But I suggested that what you got from that kind of reflection would be very interesting but thin. To travel, it would lose explanatory depth. And here, that interesting but thin thing is pointing to the invocation of secularism in Quebec as encoding something special about appeal to a relationship with religion that remains important, maybe even genetic, to defining contemporary political community and the nature of sovereignty, at least in a nation-state frame. Secular is one of those rhetorical resources that can be grabbed to engage with that project. And that's what was happening in Quebec. But it is, of course, far from the only way in which invocations of special relationships with religion are used in defining and describing the nature of political community. That special relationship, in very different ways of describing it, is crucial to Israel's political identity in contested sorts of ways, to India, to England in very interesting ways, to Italy, to Turkey. And as an outsider, albeit one who has studied a little bit in the United States, I indeed hear that drive to a claim about a special relationship in the United States in the quite specific, particular, even idiosyncratic language around non-establishment and free exercise that accretes in the jurisprudence on the First Amendment. But the most interesting lesson to me in the close examination of the happenings in Quebec is, though that's interesting and thin, we actually gain not that much of interest from general reflection on the demands of the secular. And indeed, it stops us from seeing what's really at stake, the political motives, right? The salient histories, the local inheritances in this particular moment in Quebec. And indeed, taking the demands of the secular, the claim that there is a working out of the nature or claims of the secular too seriously, too much at face value, actually ends up revealing less about this important moment, hiding the most revealing contours, actually, about this episode in North American constitutional history. So I'll stop there and look forward to questions.
So we have some time for questions. 20 minutes, Dan.
It was really a quite wonderful talk, and I enjoyed it a lot. I think it was tremendously revealing. In terms of the charge of xenophobia and the apparent anti-Islamic aspect of this proposal, how much do you find that to be? I can. How much is that explicit in the sovereignty story, and how much of that is not explicit? I mean, in France, for example, you have a very large Islamic population, and I think, and I've got a colleague who is from France, and as she explains it, sort of their ban on religious apparel and the like is heavily infused with their version of sovereignty and culture and preservation of French culture, and they don't even see it as discriminatory in the sense that we in the United States would certainly see a ban discriminatory. I don't even know about the demographics of Quebec. Does Quebec have a large Islamic population? How much of that is doing work? Is it doing any work at all?
It's a great question. So it's another way in which you can see the appeal to France as being both kind of true and yet misfit, right, in some way. So certainly North Africa matters deeply to France's definitions of the secular today, right? So it hasn't always been the case, right? The target of laïcité for most of the Third Republic is, of course, Catholicism, right? But this changes as the society changes, and the patterns of response that you see in all sorts of different systems, where Islam is taken as the centerpiece of the concerns around the excesses of religious accommodation, certainly is part of the dynamic in France. In Quebec, you know, an example, for example, people spoke a lot about turbans, right? Well, there's, you know, numbers in the hundreds of turban-wearing Sikhs in Quebec, right? It's not maybe thousands, right? And very, very small numbers. I'd say no more than these. It was no more or less about Islam than it has been in Ontario or in other parts of English Canada, except insofar as what it was deeply worried about were performed versions of religion, and a salient version of that right now in Quebec, in Canada, in the United States, in the world, for reasons we all know, right, is the performed and clear versions of belonging to Islam in some fashion. So it's not stitched in to the story of Quebec the way it is in France with the North African experience, but it's pulling on lines of all of those elements. What's deeper, I think, in it is that complex kind of double bind that as a community that's trying to understand itself as a cultural community, as a nation in some fashion, is on a really difficult ledge. There's a kind of maligned version of Quebec identity that is called pure land, right? That's a pure line of Quebec, of original French inhabitants through Quebec into the modern, and that's what a real Quebecer is. Most Quebecers don't accept this, but it shows the kind of volatility of identity claims when you're trying to do a form of political community that is tethered to language and descent and all of these sorts of things. So Islam clearly presents itself in Canada, forget Quebec, Canada, as one of the major targets of worries about the excesses of religious accommodation. But Quebec is kind of interesting insofar as it's invoking a much more structural history from France. Dan, is that helpful?
Yes.
Yeah,
I thought it was a fascinating talk too, and I was curious about the relative weight of religion and secularism in this debate about sovereignty. I guess I specifically wondered if there's something salient and significant about religion, or if it's merely one weapon in a quiver of possible tools to assert some kind of regional identity. So if you took the world tour that you just had and didn't go to Israel or India or whatever, but instead went to, I don't know, Scotland or to the Basque region or to Texas or other places that are asserting a kind of regional distance from the nation state they're in, but not on religious grounds, is that different somehow than the kind of argument you're making about the use of religion as a source of identity and its relationship to the secularism?
Yeah, thank you. I like the language of an arrow in a quiver, sort of in using this, and indeed, Winnie's class, graduate class in religious studies, I was in the class yesterday, and we talked about, the language I used was kind of a move in a repertoire of moves that you could use for secularism, or in this case, sovereignty. Like, you have a number of available resources. The interesting question is, when do which resources become attractive and salient, right? So is there something special about religion? Well, sure. You know, the long history, I think, points to ways in which there's complicated claims about sovereignty that are tucked into claims about religion, can be tucked into claims about religion. The unfolding of legal traditions and their play off of law within religion. And so the structural ways in which religion as another source of normative obligation and belonging lends itself to contrastive use when you're trying to do that with a political community, I think does make it special. There's nothing, though, intrinsic about appeal to it as necessary in projects of sovereignty. I wouldn't make that claim. Sometimes different sorts of claims will be more useful and salient than others. This is a moment, I think, conditioned, and I hope that came through in the way I put it together, conditioned in part because there was this excitement already present around issues of religious accommodation that came out of a Canadian experience of multiculturalism that then offered the use of religion as particularly appealing, effective and appealing. So I wouldn't expect to see it everywhere, but I'm unsurprised when I see it anywhere, would be kind of the way I put it. And even, I wonder about Texas. I don't know the country, but are they not using religion a little?
I don't know.
Maybe like I just don't know. Yeah.
Scotland, certainly. I mean, religion, you could tell a similar story surely about Scotland in terms of its relation to the United Kingdom that he told between Quebec and the rest, and the ROC.
ROC. And in fact, I'm going to a conference in, this is an interesting point from the constitutional design perspective. We're going to a conference in Bologna. I know it's tough, but I have to go to a conference in Bologna on federalisms. And it turns out that, of course, the person who was going to come, so it was going to be paper presentations, but now it's going to be a round table. And the reason is because the person coming from Scotland said, I don't know yet. I can't give the paper. I want to talk about it, but I don't know yet. And the person coming from Canada said, we don't really know yet. Like, I can't give the paper. This election has to happen. And you start kind of packing through the various places in which federalism and separation, federalism and sovereignty, it's really alive right now. I mean, it's always interesting, but it seems like right at this moment is a very volatile moment in questions of federalism and secession. And religion is, I think, there in most of them in some form.
Sarah.
So you mentioned that this is not a conversation that's going to end. And one of the things it seems that this charter does is to determine the framework and the terms in which communities talk about, in which communities are talking about religion and culture. And I was wondering what you would see, or if there has been any response from individual communities, who have decided to use these terms to define themselves, or to resist these ways of describing themselves, and what the benefits and drawbacks might be of different communities using this kind of framework and this language when they're responding to it.
That's a really lovely, subtle kind of question on this, and it's there are a couple of things there that you packed into that. One is, what has this done to the frame of debate?
Mm-hmm.
And a second is, are there any things that are maybe attractive about the responses and elements of reaction that come out of this? Because of course, part of what I was saying was this energized a whole bunch of reactions to this proposal. Is there anything kind of interesting in is that more or less that came out of those sorts of things? So first on the frame, right? Great question, and we were chatting a bit about this, about how it's deserving of its own study, how politically and legally, you get this proposal, right, which is a radical proposal in the scheme of what had been suggested thus far in Canada. And then the Liberal Party, who won the election, kind of a landslide election, says, we won't go there, but we'll go here, right? It turns out that's well short of the proposal, but well past what anyone was suggesting to that point. And the great example of this in Quebec was the concession made, even by Charles Taylor in his report, that, listen, I won't go there. This is exclusionary, it's damaging. Of course, a judge or a jailer or a police officer, someone who's exerting, and they were hard pressed to say what exactly distinguished them, but exerting kind of legal authority in a certain way can't wear these symbols,
but you can't extend it that far. Well, and then you say, hold on a second. Well, police officers in Canada wear, like the RCMP, like our vision of the Mountie now includes a Mountie with a turban, and it's lovely, and it's been that way since the 80s. Judge, I'm far from convinced there's anything wrong with a yarmulke wearing judge sitting there and giving reasons for judgment. It's not, so the whole shift of the terms of debate kind of got reframed, which is I think a kind of persistently interesting and yet so common that it's almost a banal thing for me to say, which is that you make the suggestion, the terms of reference have shifted. And so one of the important questions is, even though this is sort of dead for the time being, or it's on back burner, has it changed the terms of reference for talking about law and religion in Canada? We kind of have to see. But one good thing about it, and this is to your second point, is that Quebecers became more aware through argument against the secular charter about the ways in which people who would offend it, right, if it came into law, were already contributing quite comfortably to society, right? And so, in a way, just as much as secularism and this French laïcité became more salient, so too did the ways in which failure to toe that line is kind of unproblematic. So your nurse, right, who wears a hijab, right, and your police officer who wears a turban, and your university professor with a kippah, and all of these. So there was, in a way, a kind of, the best light I could put on it was there was a cultivation of a certain kind of empathy, too, around who would get lost in this that maybe could be an attractive outcome. Does that help?
Thank you.
Yes, Dave?
So I also really enjoyed the talk very much. I especially enjoyed the way you talked about religion or secularism as being a move among a repertoire of moves, or an arrow in a quiver, or a tool in a toolbox. And you gave this wonderfully finely rendered interpretation of the cultural reasons for the way this played out the way that it did. It might also be interesting to reflect on the political reasons. That is to say, some of this is cabined by what's available in cultural nuance, but some of it is in terms of political incentives and political moves that are available to be made at the chalkboard in the way that religion might interact with that. Part of what I was struck by in particular as you were talking about this is that I suspect played out very differently in a parliamentary system than it would have in a presidential system, because the incentives and the available political moves are quite different. You can't have snap elections in a presidential system, so you can't manipulate the cultural moment in the same way. And so, this is what I was reflecting on throughout, that clearly all these people, the moves available are in part determined by culture, but the reasons for making the moves are heavily determined by political incentives.
The reasons for making the moves, yeah, I'm not sure. That's very helpful, and I think right that whether or not one picked that arrow, right, depended a lot on the political and legal structures in which you find yourself living. That's the point. I agree.
And which
fully
opened
with
up
that.
opportunities to close up.
It opened some and it closed others, and it also produced, for example, you've given one example because of the snap election in the parliamentary system, but also the notion of minority government.
Well, right.
Is something that
Right.
that would actually limit where they could have gone. So if it was a majority government in a parliamentary system, it was a majority government, this wouldn't have been about a snap election. It would have moved directly to the second phase of what I described, which was pass it
Right.
and test it.
Provoke the court.
Yeah,
And of course, it would also have been different if the court hadn't had anything like judicial review. It would have been different if it had been in a parliamentary system where
Yeah.
minority governments are not allowed.
So the point is well taken. I don't know if it urges. The point is well taken when you add it as amongst the things that make a particular move attractive or not attractive. Those are the motivational ones, and also available or not available, right? But there are also things that one can do in a presidential system that are aggravating on the points of secularism and religion that are not available in the parliamentary, and the nature of the vote, the districting. And I love this image actually. This is it's just such a packed image. It's almost, this looks like any parliamentary chamber. And of course, the Prime Minister just sits here, right? right? There's no separation between the executive and between the executive and the parliament. And so it's this French place. There's only one flag if you look next to the speaker. It's Quebec's flag. There's no Canadian flag. It's the National Assembly. But it's structured like any of the houses of parliament you'd see in the Commonwealth, right? It runs on a parliamentary system. There's deep affection for that system, and there's this crucifix. And so it's all actually pretty pregnant, with the things that you're describing, which are the structural, there are motivational things that might make you pick a quiver, there's historical things, and there are also structural realities.
So I think this is maybe a little more of a comment, but it seems to me that there's a bit of historical irony in part of what that charter is doing is saying good religion interior, bad religion exterior, or bad religion ostentatious. And it's interesting to me that that's coming from a milieu that you're describing as kind of Catholic and post-Catholic, especially because that's an accusation that Protestants lob at Catholics all the time. Your religion is like it smells and bells, it's ostentatious, it's very public, and real religion is this interior stuff that is quiet and about your own personal thing rather than a public performance. So I think I just would like to hear you talk. See if that makes sense as a historical irony to you, or...
Well, this is where the two stories that I presented as really alternatives are much more mutually imbricated, right? So there is a real way in which Quebec society, though Catholic, right, is also a child of the Quiet Revolution. So they're viciously anti-Catholic in a way that I'm not sure if this is ironic or actually just demonstrative of the complexity of the Quebec society, where they're like, I want my, I dare you to take that down.
Yeah.
I dare you, right? And yet, fiercely anti-Catholic in all sorts of forms. So there certainly is a participation in the legal regulation of religion, when the legal regulation of religion seems insistently to be the prioritization of a particular branch of Protestant religiosity. And they're doing that in Quebec in a way that they couldn't be doing if not for the Quiet Revolution. So that's the kissing point between the two narratives, I think. Yeah. You're right to point that out, absolutely right.
So, Patrick?
Thank you for the talk. I really appreciate it on many levels, one of which was to remind us that terms like secularism, laïcité, or even neutrality of the state, or implied in your talk, religion and the sacralization, or the inverse of that, are not innocent terms. That they are terms that are structured and informed and determined by a variety of imperatives. But I have a question that might be a bit outside your bailiwick or your jurisdiction that has more to do with the most recent electoral results from just a day or two ago, and the idea that that the Charter of Values seem to be a way in which the Parti Québécois was trying to align an identity with that of French identity, in the sense that that we're going to pass laws that are similar to laws that are being passed in France. Whether that's historically ironic or there's some sort of disjunction there, that doesn't matter. And yet the law, the charter wasn't passed, and the party lost. It was trounced by the Liberal Party, from what I read on the news yesterday.
Yeah,
So I'm
trounced
curious-
is right, absolutely.
So I'm curious as to then what, since this arrow didn't fly too far, what does that, and this is where I suggest that it might be outside your jurisdiction, but what does that say about that the use of this as a political move? I mean, it didn't seem to have much traction. There wasn't much left underneath.
Oh, it had a ton of traction,
Okay.
but what it does is point, so it hasn't, we don't know how far it's really flowing yet. Like, we don't know what's gonna be done with it. It's in the air, and we'll see. You're quite right to say, but hold on, right? They lost.
I wanna just take the last question,
Okay.
which is over here next to Susan. I'm sorry, I don't know your name.
So I
And then maybe we can.
Yeah, I'll do both of
Because
these.
I think we're running out of
Ask me
time.
about the future, I guess I want to go to the past
Okay.
briefly. On these two stories of a break in continuity, the continuity does seem to be a curious one, because if this is related to religious difference, right, as you say, this is Catholic in a sea of Protestants, and then from the Quiet Revolution, it's different secularisms or something, right? So I accept that can be a continuity, but it's a very curious one. So I was wondering if you could say more about the relationship of the Quiet Revolution to this new story about sovereignty, because the continuity is that there's always a sovereigntist issue, but as I understand it, in the moment of abandoning a Catholic political identity is also when you have the real rise of strong separatist sentiment. So it's an odd thing to give up a really different identity point for a more subtle one.
Yeah.
And I'm wondering why that, it's not the only place where religion is put out in favor of a linguistic nationalism, but why is this resource, this one really big arrow, put away?
Great, let's chat after.
I think we
we're out
need to
of
move
time.
out into this, sorry. Thank you very all for coming.